Good morning, this is your Kelso Report for Monday, March 4th, and I'm your host, Clark Kelso. We start today with two Supreme Court decisions, the first involving the proper interpretation of a general civil regulatory action statute of limitation, and the second involving proof of materiality at the class certification stage of a securities fraud case. Then we turn to the Ninth Circuit, which issued a decision dealing with water deliveries to the Central Valley, and we close with a state law case involving the doctrine of equitable contribution. Let's start off with the Supreme Court. As I'm sure you're all aware, over the last 100 years or so, courts interpreting statutes of limitations have frequently applied a discovery exception, pursuant to which the statute either does not begin to run or is told until the plaintiff knows or has reason to know of his or her injury and the possibility that there is a cause of action. The early cases often involved medical malpractice actions following surgery, where the surgeon left a sponge inside the plaintiff, and the consequences of which did not become apparent until after a short one-year limitation period. Well, in Gabelli v. SEC, the Supreme Court had to decide whether to apply a discovery rule to the 5-year limitation period given to the Securities and Exchange Commission for bringing an action for civil penalties against investment advisors who have allegedly defrauded their clients under the Investment Advisors Act. The SEC argued that the 5-year clock should not begin running until the fraud was discovered. The Supreme Court unanimously rejected the SEC's position, relying upon the plain meaning of the statute, which provides that, quote, "An action, suit, or proceeding for the enforcement of any civil fine shall not be entertained unless commenced within 5 years from the date when the claim first accrued," close quote. According to the court, the claim accrues when the fraud is complete and there has been an injury. Nothing in the language suggested that a discovery rule should apply. The SEC tried to argue that frauds are by their very nature things that the defendant tries to conceal, and that in private actions for damages involving fraud, state and federal courts have applied a discovery rule. The court rejected this analogy, noting that the discovery rule is applied in those civil actions to safeguard the injured plaintiff's ability to recover damages. The SEC, by contrast, is an enforcement agency that is supposed to be on guard for fraudulent activity, and so there is less reason to apply a discovery rule on top of statutory language that expressly gives the SEC only 5 years from the accrual of the cause of action. And since that limitation period does apply more generally to civil regulatory actions, this case is going to have a rather broad impact on government regulatory actions. Next, we have a case under the securities law. One of the elements of a common law fraud claim is, of course, that the plaintiff relied upon the fraudulent information provided by the defendant. Proving reliance in a securities fraud class action would be difficult, since many investors in stocks buy and sell without having personal knowledge of the allegedly fraudulent statements. This problem has been solved by the so-called fraud on the market presumption, which the Supreme Court has endorsed. The fraud on the market premise is that the price of a security traded in an efficient market will reflect all publicly available information about a company, and accordingly a buyer of the security may be presumed to have relied on that information in purchasing the security. This means, among other things, that plaintiffs can get their class action certified without having to demonstrate individual reliance. And that would be a problem if you had to demonstrate individual reliance. Individual questions would predominate over common questions. Well, the issue before the Supreme Court in Amgen v. Connecticut Retirement Plans and Trust was whether a class could be certified without making a showing that the allegedly fraudulent statements were material. The defendant argued that without a showing of materiality, the underlying premise of the fraud on the market theory was missing, so class certification would be inappropriate. The majority of the court rejected this argument. The plaintiff certainly must ultimately prove materiality on the merits, but the court held the plaintiff was not required to prove materiality at the class certification stage. As the court noted, Rule 23b-3 requires only a showing that questions common to the class predominate, not that those questions will be answered on the merits in favor of the class. Next, we turn to a Ninth Circuit case involving allocation of water. Farmers in California's Central Valley are dependent for their water upon decisions made by the United States Bureau of Reclamation, which sets water distribution levels for the Central Valley project. In dry years, the farmers regularly fall short of the water they desire, and they have turned to the courts for help. In San Luis Unit Food Producers v. United States, the farmers argued that federal statutes require the Bureau to provide irrigators with sufficient irrigation water to satisfy the farmers' needs before delivering water to any other party for any other purpose. The Ninth Circuit dismissed the farmers' claims for a number of reasons. First, and most important, the court simply rejected the statutory priority argument, holding that the Bureau is not legally required to take any discrete actions to deliver the farmer's preferred amount of water before it provides water for other purposes. Instead, the Bureau retains discretion to allocate water among various parties to satisfy its various obligations. In addition, the court held there was no final agency action to be reviewed under the Administrative Procedure Act and no action that the Bureau had unlawfully withheld. So there was no subject matter jurisdiction at all under the APA. Now we turn to a remedies issue involving the doctrine of equitable contribution. Equitable contribution is an equitable remedy by which one person who has been held liable because of the actions of another can shift some or all of that liability to the other person. One of the key issues in an equitable contribution action is, of course, the basis for making the allocation. Should all of the liability be shifted or only a portion? And if only a portion, how much? And how do you determine how much? The Fourth District faced this question in Guide 1 Mutual v. Utica National Insurance, which was an equitable contribution action involving 3 insurers. One of the policies covered an employee who had negligently caused injuries to another person while driving his car in connection with business for his employer. The other 2 companies had policies that only covered the driver's employer, who was vicariously liable for the actions of its employee. The employee's insurance company settled the underlying action and exhausted its coverage, and it then sought equitable contribution in the amount of $600,000 from the employer's carriers, claiming that it overpaid based upon a pro rata share of coverage. The Fourth District rejected this argument, applying the rule that a primary insurer has to fully exhaust its coverage before it can seek any type of contribution from an insurer whose insured was liable only by virtue of vicarious liability. The insurer of the vicarious liability, that coverage is secondary. And until you go over the policy limits of the primary carrier, equitable contribution does not attach. And that's it for today's Kelso Report. Have a great day in the law.